We understand the difficulty that the NCE examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaaguides.com. Join me in welcoming your guide for this session. Thank you.
Thank you for that. So now, do you guys have your syllabus printed out, or you have it with you right now? Ragav, am I pronouncing your name properly? Do you have your syllabus? You are muted. We can't hear you. Unmute yourself and talk.
Yeah, you're pretty close in pronouncing your name. Hello, first of all. Yeah, I have it on the phone like right now, but I don't have it printed out, so I'll just.
It's okay. All I want is for you to have access to it.
Yeah.
So you have access to it. If you're Lua, do you have access to it? You good? Samira, do you have your syllabus with you?
Yes, I do.
That's fantastic. Okay, so I would like to ask which of us have attempted to write the NCA's exam in the past? The reason I've asked this question is so I know if I need to pay some attention in giving you a structure or as to what NCA exam requires. If some of us here have attempted the NCA exams, there'll probably be no need for me to go in all the way in on that. So have you, I can relate with if you're right now, have you attempted the NCA exams before? No? Criminal law will be your first, or which ones are you writing together? Please unmute your mic. We can't hear you.
I said I've not decided yet which one.
Okay, yeah, you're still, I know. Okay, it's okay. Raghav, have you attempted any NCA exams? Great.
Yes, I've done 3 exams, so now I'm writing criminal law and PR.
Fantastic. So you are a pro. You have an idea what you should be doing as per structure of NCA exams.
For criminal law and PR, I'm in total dark, but for the others, yes.
Fantastic. You're on a good track. Samira, Anwuli, please come in and let us know if you've attempted any NCA exams in the past.
Yeah, I've attempted 3 in August, the last.
Okay.
So I just have criminal and PR.
That's great. Who else? Adiola, do you want to come in now? Have you attempted any NCA exams? Okay.
No, not yet.
Okay. So criminal law will be your first, or have you also not decided like if you're lower?
No, I'm not sure. That's why I'm taking a review of everything, so I would know what to take first.
I understand that. That sounds good. Samira, how about you? You good? Have you attempted any?
Yes, I did the last August diet. I did criminal law, but I'm thinking of taking it again in September.
September, okay.
But I'm not yet.
Okay, so you're yet to do some sort of check, like should I or should I not?
Yeah.
Okay, that sounds good. Okay, all right, that's okay. So what we're going to do for the class, now that I know that most of us have attempted it, I mean, apart from Ifeoluwa and I think Adiola, I would not take so much of our time to go through what exactly you should be doing, but probably at the end of the class, a minute or two to just guide as to what NCA requires. But as per criminal law, we are here for criminal law and the focus should be on criminal law. I know we are lawyers from our various jurisdictions and we must have attempted criminal law before, it's given. Either in your 200 level or 300 level in school, you must have attempted it. So we have a pretty good idea what criminal law is all about. So basically, criminal law is essentially a body of law that relates to crime, and it basically prohibits conduct, perceived to be injurious, to society. So that's basically what criminal law is all about, right? So now when we're looking at sorry, I may be distracted because I'm trying to admit people into the class. So now that we have an idea what criminal law is all about, at least Please, may I request that you mute your mic? Hi,
Dad.
Hi, Musabelo. How are you?
I'm fine. Can you see my camera? And I was trying to explain that I couldn't use the camera because my battery, and I was removed immediately. I was trying to figure out how to unmute my mic. I was given a chance. I raised my hand and you removed me immediately.
I noted you raised your hand and I just couldn't understand
Yeah,
what was happening. We are happy to have you here. We are happy to have you here. Okay, so let's please go ahead with the class. Musabelo, before you joined, I asked a couple of persons. Are you with us?
Yes, I am.
I've asked a couple of us on the call if we've attempted NC exams before, just so we have an idea how far or how well we are into it. So I'm going to ask you the same question. Have you attempted any NC exams?
Okay, so I put on my mic, my camera, so I can quickly take this question. Yes, I've attempted. I wrote 3 exams in August, and this is about my 4th one right now. Yeah. Okay,
so you're taking this in October, criminal law in October?
Yes, I'm taking criminal in October.
Okay, that sounds good. So welcome to the call. So as I was saying, we're going to adopt a very interactive approach here. I want to give us a shared idea of what criminal law is. Let us understand the principles. Let us understand the nitty-gritty or some sort of background to the course, so that we have some things to place on when we're studying for the course. We have a foundation to place on the course content we'll be going through. So having said that, now that we know what criminal law is, we should also understand some basic principles of law that informs why criminal law is very important. So we'll be looking at issues of principles of fundamental justice, because I guess that is the whole hub of why criminal law is essential for us to understand. So principles of fundamental justice, basically your auditory pattern, your presumptions, your presumption of innocence, and all of that is very important and key germane to understanding the cause. So what are we talking about essentially? Is that for your auditory pattern, you understand that all parties must be heard before a case can be tried, and before it can be seen that justice had been done. You must be given an opportunity to defend yourself in any criminal case. So it is important. It is on that basis that you have your presumption of innocence as well under your section 11D of the charter. So if you understand this, you understand why it is important and why we must actually understand the course content, and why it is important for you as a Canadian lawyer to understand the basic elements of criminal offense, and when somebody's or an accused liberty will be deprived, and in circumstances that it will be deprived, as well as what would happen when it is deprived. So it is important we have a shared understanding of all of that. So having understood that, we would look at discuss the concept of fundamental justice, as well as understanding the presumption of innocence. The next thing we'll be doing now is to go through our syllabus and see how we can run down the course content, and how we can begin to pick out and highlight what is important for us to note. Your essay syllabus gave you about 30 chapters, starting from your sources of law up until appeal. Is it 30 or 31? So you'll be looking into all of these chapters, about 32 actually. You have 32 chapters in your syllabus. So essentially, your criminal law, as I like to put it, even though it is 32 chapters, in my head, what I've done for my students is to actually break it down into about 5 parts. You have like 5 parts. So you have to concentrate on your offense sections, offenses, very important. Your defense sections, very important. Your police powers, very important as well. Sentencing, super important. And the 5th one will be the procedural aspects of it. So even though you have 32 chapters in your syllabus, the moment you understand that you can break it down into these 5 parts, and you begin to compartmentalize it into this segment, you will be good. You begin to have a good structure of what to do, or what you need to do when it comes to criminal law. So I've mentioned 5: offenses, defenses, sentencing, procedure, police powers, You know, did I mention all the 5? Those are the five segments you'll be looking at when you're talking about criminal law. So now, for the offense part of it, you will look through your syllabus. You will actually not see anywhere where the NCA actually listed offenses you'll be looking through. And this is because it's actually impossible for them to do so. Because you have about how many offenses in the criminal code, it is impossible for you to actually review all the sections regarding to offenses in the criminal code. However, what the NCA had done is to give you some offenses, examples, and they slotted these offenses in when they were talking about your elements of the criminal offense. So you'll be looking through the elements of criminal offense, which we will look through during the course of this call as well. And then under this elements of criminal offense, they've treated some offenses by bringing in some cases that touch on those offenses. So with what we've seen that NCA had done with their past practice is that some of these offenses that they've actually used as examples to explain elements of criminal offense, they tend to focus on it in the NCA exams. For example, murder, manslaughter, assault, robbery, fraud, which other one? Arson. There are quite a number of them, but these 5 or 6 I've listed, NCA as sort of, by virtue of their past practice, informed us that these offenses are important. And you would understand why, because those are the offenses that are quite common that you find people commit. And as a criminal lawyer, you should know, either as a crown or a defense lawyer, how to deal with those offenses. So in the course of our class, we will be making some, taking some effort to explain elements of those offenses. Now, what the NCA had told us in the syllabus is that they know realistically that you are not going to be able to touch on all the offenses, but what they want you to do is you should be able to review any offense section that had been given to you in the exam. And that is the focus of this, of the NCA guides. That is the focus of what our classes would be. One of it would be that you will have the ability to review any offense section that you may be given in the exam. How do we achieve that? We will understand concisely, precisely, beautifully, we will be able to tell what the element of criminal offense is. We will understand it during the course of the class. So that is one aspect, offenses. The focus for offenses is your ability to know the element of the criminal offense, to identify the element of criminal offense, and to be able to review any section that has been given to you. That will be the focus for the offense part of the syllabus. Remember, I told us that we are breaking it down into 5 parts. So that is the first part, that is the focus. Now the defenses, what are we looking at for defenses? There are 2 types of defenses. You have the statutory defenses. Those are the defenses mentioned in the criminal code. And then you have the common law defenses. What we will be doing with these defenses? We will learn how to identify when these defenses will be applicable. We will know what are the elements that the defense would have to prove on the balance of probability before the defense can avail him. We'll be looking at different types of defenses. What the syllabus has also done to you or done for us is to tell us that defenses we'll be treating are actually very, included in the syllabus. What does that mean? You don't need to bother. Unlike the offense section where all you need to do is to, know what to do with whatever offense you've been given. For the defenses, they've listed them, and that will be the focus. The ones listed are the ones we are looking at. They are about, I didn't count them, but they run over like 10 or so. You'll be looking at duress, you'll be looking at mental disorder, you'll be looking at automatism, you'll be looking at provocation, you'll be looking at intoxication, defense of a person, defense of property, necessity. Those are examples of the defenses we'll be looking at. How and when will the defense be applicable will be the focus of the defense part of our class. Is that clear? Are we together? I like to hear feedback when I talk, so I don't sound like I'm like a radio talking to yourself. You guys know what I mean?
Yes, we are with you.
Yeah, thank you. So that is the defense part. That will be the aim And at the end of the class or at the end of the review of the defense section, you will know, trust me, you will know when it applies, when which defense applies and when it doesn't apply, because we'll be looking at through the test, we'll pick it each one after the other. That is the defense part of the class. Now, which was the next one I mentioned? Police powers, very important. What I've observed with police powers is that the NCA, I've not seen any diets without police powers. I've not seen it. If you have seen it, let me know. In your review of past questions, maybe you've seen that the NCA didn't bother about police power. They will bother. Do you know why? Because the police powers is some sort of balancing of the police powers and the right of the accused person in society. It goes to principles of fundamental justice. It is important because if the police can exercise their powers arbitrarily, then it means we don't have a safe society as well. And then the accused persons themselves, they also have to understand their limits. So it is in ensuring the rationale or the jurisprudence of criminal law, it is important that we have pretty good understanding of what police power is about. So in police powers, you'll be dealing with some pretty good sections in your charter. You can't escape it. You'll be dealing with your section 8, which talk about your right against unreasonable search and seizure. You'll be dealing with your section 9, which talks about your right against arbitrary detention. You will be looking at section 10, and section 10 is further divided into 3 because you have your 10A, your 10B, and your 10C. Your 10A is telling you that the accused person has a right to be informed of the reason of his arrest. Your 10B is telling you that upon arrest, your accused person has a right to what? A right to counsel. And then your 10C is telling you that in the event that the detention of the accused person is illegal, the accused person has a right to be released, and that will be your right or your application for the writ of what they call habeas corpus. So you'll be dealing with those 3 sections when you talk about police powers. That is the highlight of police powers, and you'll be looking at numerous cases all through. This is where you also have a series of tests that you'll be looking through, so that when you begin to study, when you pick up your course material, some things should start ringing in your head when you pick up the course material. You'll definitely be reviewing the case of Aaron Collins in police powers. It is fundamental, you can't miss it. And when we go down deep in your police power, you will understand that you also have the common law source of police power. And under that, you will need to be dealing with your case of Aaron Waterfield. That is where your Waterfield test come in. You will also need to talk about that. There are quite a number of cases under there, but very important is Aaron Collins. I don't want us to miss it. In class, we will definitely have to go through it line by line to understand what the test is about. So for the police powers, that is the focus. You know, so with what I've said so far, I've touched on offense, I've touched on defense, and I've touched on police powers. I want to believe that we now have a pretty good idea of what these things are about, because that's the whole essence of this introductory class, to jolt our mind, to provoke our mind and thoughts as to when we start to read. So that is offense, that is defense, that is police power. The next one is what? Procedure. Under procedure, you have quite a number of topics. You'll be dealing with pre-trial motions. You'll be looking at the powers of the prosecutor, the powers of the Crown, and when they need to exercise their discretion. You'll be looking at issues like what will be the role of the court when the Crown is exercising their discretion. You'll be looking at also the duty of the defense counsel. What should the defense counsel do? This one actually takes us back to some certain code in our professional responsibility. We'll be looking at the model code to understand the duties of the defense counsel as well as the duties of the Crown. Basically what that is that in trial, you understand that there are different levels to trial. For example, the Crown that is instituting the action will file the case, and then the defense would have the right to file its defense. And then during the actual course of trial, I know we are all lawyers, I should not actually take too much time on these. There are steps and stages to it. So you have your examination in chief. What are the duties of the Crown in examination in chief? The cross-examination, and so on. You'll be looking at the issues of admissibility as well, and then relevancy. But For NCA, I have observed that NCA would actually not delve so much on the procedure. So I'll probably, I'll say pay attention, but not as you would in detail, because they'll probably not ask you to test, evidence in exams. But for you to know the duty of the Crown and the duty of the Defense Counsel, that's super important. And one of the cases you'll be looking at under that is the case of Aaron Nixon. And that's the case where the prosecutor entered a plea bargain and then withdrew the plea bargain. And the judge, the issue was whether that withdrawal would amount to an abuse of power. We'll be looking at issues like that when you talk about procedure. So there are other things under that as well, but I just want us to compartmentalize our discussion in that way. So we have offense defense, we have police powers, and then we have, which one, who is following me? Which one did I just talk about?
Sentencing.
Okay, so the next one will be sentencing, right? Right, the next one is sentencing. For sentencing, it's pretty straightforward. What I always tell my students is, the moment you get a question on sentencing, the first thing you need to do is to check the offense section where your accused person has been convicted. What did the section say? Did it provide a minimum, sentence, a minimum imprisonment, term of imprisonment? Is there a maximum term of imprisonment? The moment you answer that question, if you go through that section and you see, for example, there is no minimum term of imprisonment, it takes you to some certain sentencing principles straight up. You can now consider probation, you can consider fine, you can consider community service, you can consider, which one is it? Quite a number of them actually. But the moment you have a minimum requirement, a minimum sentencing prescribed, it takes away the ability for you to look at all of these ones that I just mentioned, because now there's a minimum requirement. The judge will not have the discretion to go below that sentencing requirement. Are you with me? The judge will not have the discretion to go below. So it's the moment to answer that question, is there a minimum, term of imprisonment imposed or not? It streamlines your thoughts straight up, and the ones you should be looking at and the ones you shouldn't be looking at. That is for sentencing. And then basically you are going to be reviewing your section 718 of the criminal code, because that is where all your sentencing principles are, right? So that is my, structure, and that would be the way I'll be treating the class as well. So now I will take us back, and then we begin to look at the syllabus, chapter by chapter. Hopefully we'll have enough time to run through them, okay? For those who had not written the NCA exams before, let me quickly say this. Okay, Raghav? Yeah, please go ahead.
I have a question.
Yeah.
I'm yet to start studying for the criminal law exam. So the question is, where do I start studying? From the notes or the procedure or the code, the criminal code? And about the criminal code, I don't understand the role of it. I mean, in the sense that, do I have to read the whole thing, or how am I supposed to deal with the criminal code? Please help me out with that. I'm really confused. Thank you.
That's why I'm here. I'm just here to help. That's a very good question, actually. I actually have it penned down in one of my to-dos for the class today. But now that you brought it up, I'm just going to talk about it straight up. So the first course, and this is me, this is what I do as a student. I know I'm talking to you as a tutor now, but as a student, the first thing I do is to pick up my syllabus and read it from the beginning to the end. That gives you the whole fair deal of what your course is about. And then if you go through your syllabus, you see some tests actually that the NCA had recommended. Let me show you. The NCA recommended what we call the Kent Roach and Steve Pullen. One is for procedure and one is for law. This is the criminal law. Can you see me raising this up? I know my background might sort of interfere with me raising this up. Let me, I don't know, I have to show you this textbook. So I'll try to change my background now so that I can show you. Just give me a sec. What do I do? No, right? How do I take this background away? I don't even know how to take my background away. This is so hard. Okay, I don't know what to do, but I need to show you this. But let me just continue telling you, I will eventually have to find a way to show you the textbooks, because you have two textbooks that the NCA had recommended for you. Kent Roach, it is on criminal law, and then Steve Kulan is on procedure. So one textbook focuses on the law and the other one is focused on procedure. Those are the recommended tests. There are the optional ones as well, but I know most of us, I mean, I don't know, unless you are some guru and you want to read everything, but the optional ones are there for you as well if you want to consider it. But I focused on Kent Roach and then Steve Kulan. Now, Raghav's question, I understand that the textbooks are bulky. I understand that particularly if you're merging other courses with criminal law, you probably don't have time to read the textbook, which is why you have notes. There are people who've dedicated their time to streamline the content of these textbooks for you. And they are great, source for you to read as well. We have one on our website by Manuel Akishola. He's a great author. So what he basically did was to give you a summary of Kent Roach and Kulan. So your first question, read your syllabus. If you're good to go with the textbooks, I would say buy it, fantastic, read them. If not, read Manuel Akishola's note or any other note that you're comfortable with. Then what I do for my students is that in as much as you have these notes, the notes are not your go-to for the exam. Because you are sitting exam, you're in your exam mode, you need something more than the note. The note is not as bulky as textbooks, but not as concise for exams as well. So you need something lesser. So what I have done, and what NCA Guide had done, is to give you what we call an answer framework. I'm very careful saying this because like I said earlier, your offenses cannot be exhausted. They can't be exhausted. NCA, you get to the exam and the NCA is saying, review a section on terrorism, for example. NCA has the right and liberty to bring out questions as they wish. But what we've done, considering their past practice, knowing that these are the focused, NCA exam questions, what we have done is to review all of these offenses that NCA had cause to bring question on in the past and review it for you in such a way that you are good to go and you just put them down in your exam. I'll share my screen so that I show you what I'm talking about. Just give a sec. Where's my Word document? If you can see my screen, let me know. Can you see my screen?
Yeah.
Can you see my screen?
Yes, I can.
Great. So I'm just going to, this is a work in progress. It's not on our website yet, but it's basically telling you exactly what I've said to you. For example, I have listed here a couple of offenses, over 13 offenses, right? I'm just going to scroll up to the very first one or thereabouts so we can have an idea of what I'm talking about. So for example, this is a section on, or this is an offense section on assaults. Assault is one of the offenses I'd listed as very popular as far as NCA question is about. So this is your part one in the answer framework, which will be on our website very soon. And it breaks down all the likely questions regarding offenses, as well as defenses, everything actually, having broken it down into 5 parts for you. This answer framework is also working on those 5 parts I've broken down for you. So your part 1 is on offenses, your part 2 will be on defenses, and so on. So the first offense you have here is breaking an entry. And what it does for you is it adjusts the IRAC, which is the method you will be using in your NCA exams. And it's basically picked this section and treated it like you would be doing in your exam section, right? So let's say, for example, the fact pattern you've been given is touching on breaking an entry. And another thing we will be doing in the class is for us to understand how to decipher this fact pattern, right? How to understand what the question, because that's the first thing. I mean, I don't even know how to say this for you to That is the most essential thing for NC exam. You must be able to understand your question. I mean, if you don't, then we don't even know where to start. So one of the things we try to achieve in class is to give us the skill and the ability to understand our questions. So the moment we do that, assuming your question is on breaking and entry, the first thing you need to do, no matter the story you have in your exam, because NCA is fond of giving you lots of stories, and the only relevant thing may be just the 2 lines, should be told. But those stories they give you now help you as well to, see if your elements of offense is applicable or not. How to identify it, what to do, It's quite interesting, I have to admit. So, issue, can the accused be charged with offense of breaking and entry? Your issue cannot be more than that, no matter the offense section you've been given. But I admit that what I'm doing for you right now is most appropriate for exam review. What we are doing right now is introductory, and I'm only showing this document because of what Raghav had, asked. So this is your breaking and entry. It will touch on your issue, your rule. Very essential is burden of proof. We'll discuss it in exam review. Your actus reus and mens rea, what is needed for that offense, and then you apply, and then you conclude. When you're applying, you are now using the fact that they've given you in your exam to see if it meets the rules and the principles given under that section. And then you just have to conclude whether your accused can be guilty or not. You can see how easy that would be. And now assaults, and then you have various types of assaults. Right? So this is the foundation of assault. There is no offense you get in the criminal law exam, and that touches on assault, be it sexual assault, aggravated assault, assault causing bodily harm, or assault using a weapon. You must tell the NCA about this first section on assault. So your section 265 is very important for any offense section on assault that you get. It is your foundation. So that is the foundation we're giving you as number 2, and then we now delved into the different types of assault. You can see assault with weapon or assault causing bodily harm. It explains to you what you need to prove under that as well. And all you need to do is just to simply see if it's applicable to your case or not. You are done. And then you go to sexual assault. So all of these are just different types of assault. Aggravated assault is up there as well. And then you have murder. So essentially what I'm saying is that at the end of the day, if you've read your syllabus, you've read your textbook or whatever notes you have, this material right here streamlines all this content for you. I've stopped sharing my screen now. So it streamlines all the content for you, and what you'll be doing is just to be applying, it's just to apply. You look at your fact pattern, how you apply concisely, efficiently is what we would also focus on in the exam class as well. During the classes, intensive classes itself, right? So you have your syllabus, you have your notes, you have this answer framework. Another fantastic thing you will be getting is, for every class we will be holding, maybe a day or some hours before the class, you get a summary content of the chapters we'll be treating in class. Every chapter, so I've just told us that we have 32 chapters in the syllabus, right? So for every chapter, you get a pager or 2 that tells you exactly what that chapter. So it's like a bullet point of what you need to focus on in that chapter. This is a great resource for your exam as well, because the moment you have a question and you look through your 1-pager or 2-pager, you know essentially what you should be focused on, and you'll be only be referring to your notes to flesh it up. So you can see. So I've answered your question, what you need to do. And then very important, I almost forgot, is your criminal code. This is the most essential of everything we've been talking about. You must have your criminal code. May I ask, for those of us, Samira, what criminal code did you use for your exam?
Martin.
Okay, that's a good one because it is annotated. That's what I want to highlight. You have 2 types of criminal code. The one that focuses on the sections and not tell you anything, and the one that tells you the section and tells you what the section is about. That is the annotated part. That annotated part is very important. What we'll be achieving in class as well is how to read that criminal code to the most effective way for you to pass your exams. Because believe me or not, all the answers you need in your class, in your exam, is in that criminal code. How do we read it? How do we highlight the key thing in the annotated part for the optimum use of in your exam. We will look at that as well. So we now have answered, I believe I've answered you. You have your syllabus, you have your textbooks, if you may, you have your notes, whichever one you use, but I recommend Akishola's note on the website. This answer framework I just showed you, although this is not for free, you would have to pay for it on the website. But and then you have the one-pagers for all the topics we'll be talking about ahead. So you get it ahead of each class. That one is for free, right? It comes with your registration. So those are the resources you need for your criminal law exams. Raghav, are you good?
Yes, you're saying that I should have my criminal code on my side on the exam, and I might have to refer to it. So does that tell me that I have to read all the offenses on the criminal code like they are, or okay, so I just need to focus on the class and
Raghav, it's actually impossible to read all the sections in the criminal code. It's not possible, right? What we'll be focusing on is understanding how to identify elements of criminal offense in whatever offense section you'll be given. That is the focus. The focus is not for us to go through all the sections. Okay? Got it. Thank you. Thank you. I think we are great on that. We can proceed now. So now that we have a fair share idea of what we will be doing for criminal law, maybe we should dig deeper now. We should begin to look at some key aspects of the criminal law, right? So I'll say I go through the syllabus. I see how far.
Sorry, I have a question.
Okay, please go ahead.
You mentioned just now, you said what we'll be focusing on is understanding how to identify elements of criminal offense.
Yeah.
Does it apply as you just have any offense and any other, right?
Say that again, please. You skipped a bit.
Defense, or is it just offense?
Of course not. It's in everything, Musa Bello. So what I said was that I would segment the class into 5 parts. So the focus for the offense section will be to understand how to identify the elements of the criminal offense. The focus for the defense section will be what is required for the defense to prove that this defense should avail him, what it would need to prove for all the defenses that you have in your syllabus. We will be talking about what the defense would have to prove on the balance of probability before the defense can avail him or her. You see? So for every segment of the class, we have a focus. And that is what I'm trying to raise or point out to you. Musa Bello, is that clear? So we are not only talking about, when I talk about offense, I will be talking about the focus. When I talk about the defense, I will be talking about the focus and so on, right?
All right, that's clear, thanks.
Yeah, so now that we've cleared that out of the way, let's go now to our syllabus. You all have it, I assume that. So the first topic you have is your sources of criminal law. That one, there's not much to it. For Samira, will agree with me that what essentially they want you to note is that the source of your criminal law is statutory, is in your criminal code. And then you have all of those other acts that also touched on criminal offenses, but not in the criminal code. Like you have your Drug and Substance Acts, you know, and you have a list of them actually in your criminal code, like the Juvenile Act. You know, those are sources of criminal law, but essentially for NCA purpose, we are focusing on the criminal code, right? Your syllabus also told you, can you see this one? I have to show you the text before the end of this class. Somebody should remind me. But my criminal code is Alan Gold. It could be Martin's, just like Samira has. But just make sure whatever criminal code you buy is annotated. That is the most important thing, right? So for your sources, you're looking at the criminal code, and your syllabus mentions specifically that your common law cannot be a source of criminal law. And we already have an idea why. Because your common law is unwritten, it is not definite. And for you to be charged or prosecuted for any offense, you must have notice of that offense. You must know that the offense is existing, and you must know the punishment for it. so that you can avoid to commit it. But if you have to charge me for an unwritten criminal law, I mean, that goes to fundamental justice straight away, right? So your source of criminal law, focus for NCA is the criminal code. Although you cannot have common law as a source of criminal law, but it can be a source of defense. Common law had been seen day in, day out to bring up defenses. It is a good source for defense. And under that, you will be looking at defenses like entrapment. Your entrapment is a defense that says that the police should not lead me to commit a crime. The moment the police looks at me and probably profiles me and say, oh, this one looks like she'll be carrying drugs. And then they investigate and they push me and try to force me to buy that drugs. That is your defense of entrapment. I will go to court and scream entrapment. You made me commit that offense. That is what common law tries to do, right? So your common law defense is also very important. There are quite a number of them. Your intoxication is a common law defense. There is nowhere in your criminal code that you see that intoxication. It is evoked as a result of interpretation by the judges. We'll be looking at that as well, right? So you know your sources of criminal law, you know your source of defense. The next chapter is telling you about the power to create criminal offenses and the rules of criminal procedure. That one is, we don't bother much on that, because what basically that one is telling you is that the federal government, as well as the provincial government, would have the power to enact laws to govern the state, so to speak. But here, for federal government and provincial government to be able to, the focus on the kind of laws they can enact to be regulatory together. So the federal government can regulate, enact laws regulating conduct or moral conduct in the society. The provincial government as well can make laws for social welfare of the society. That is your regulatory offense, right? So if you have offenses like traffic offense, waste management, you know, those are regulatory offenses, and your provinces have the power to do that as well. So the federal government, provincial government can regulate such offenses, can enact laws on such offenses. However, it is only the federal government that has the power to enact criminal law offenses. And this is where your difference between regulatory offenses and true crimes will come to play. This is one of the things we'll be zooming in as well in our classes, right? So, but for the purpose of this introductory class, all we need to know is that for every offense that we term criminal, what are your criminal offenses? How do you know criminal offense? There must be what they call the 3 Ps. 3 Ps. I know when I pronounce my how, it sounds funny, but just bear with me. The 3 Ps, right? So you have your prohibition, you have your penalty, and then you have public purpose. The moment you look at your law and you see these 3 Ps, you know that you are looking at criminal law, true crime, right? So that is one of the things we'll be talking more about in the class as well. But for the introductory class, it is sufficient for us to know that criminal law power resides with the federal government. For those that have done constitutional law as well, I think this is one of the things you would have touched on. But for the purpose of criminal law, it's just for us to know that the power to create the offenses will be reviewed for NCA lies largely with the federal government. But when you're now dealing with regulatory offense, which is one of the topics you'll also be talking about, you know, you are looking at both federal government and provincial government. Is that clear to us? Are we good? Right? So that is for the first.
Yeah.
Yeah, thank you. That is for the first and the second topic in the syllabus. You also have the Charter of Right listed there. And what Charter of Right does is just to, it's like, what do they call it? Like some, like check. Your charter is like a check on the activities of the federal government. So the federal government would enact your criminal law, and the charter is scrutinizing that law to make sure that it is not infringing on people's rights. So your charter is a good way that the court had used in interpreting whether a criminal offense section is constitutional or not. So that is there for you as well. We'll zoom in that on that as well. The next will be the procedural classification of offenses. For your criminal law, they've classified these offenses into two, right? They say to you that you have your summary offenses and you have your indictable offenses. For your summary offenses, what is the difference? What is the importance of this division? It would have effect when you are looking at the penalties. It would have effect when you are looking at the procedure. What do I mean? So if you have a summary offense, right, you know, like you come to see in class actually, and actually know that the moment you touched on summary offense, you are looking at the punishment of the offense that can be less than 2 years. It can be more than 2 years. So when you have summary offenses, so and the distinction between the two is very important, and the power to decide whether to proceed summarily or whether to file an indictment, that discretion lies with the prosecutor. The power to choose, does that make sense to us? To choose whether to pick a particular way to file a case or to try a case, that power lies with the prosecutor. So the prosecutor or the Crown can say, okay, I'll go summarily. I'll file a summary case. Prosecutor can say, oh, I'll go by way of indictment. I'll file an indictment. I'll proceed by way of the indictment and file an indictment. Those are the two ways. So why is it important for us for the Crown to choose? The Crown is important for the Crown to choose because the moment the Crown chooses whether to go by summary or to go by indictable, it takes away some certain power from the judge. So the moment I go by summary procedure, I'm telling the judge that this punishment is obviously less than 2 years. But the moment I file indictment, I'm telling the judge that this accused must get above 2 years. So it goes to penalty. The other thing is that it also tells on the procedure. What do I mean by this? If I file a summary case, I'm basically telling the judge that I don't want a jury trial. You know, one of the ways you can try cases in Canada is you can have a jury trial and you can have a judge alone trial. Are you with me? If you decide to file a summary case, or you proceed with your case summarily, what you are basically doing is shutting the door to a jury trial. And by practice, your summary offenses are usually the less serious offenses. But it's not a good way to separate it actually, because you have some summary offenses that are also serious. So the way you look at it is understand it for penalty and for procedure. So if I, as a Crown, for example, I want to make up my mind whether to proceed by summary trial or whether to file an indictment, what do I look at? I want to see the gravity of the offense. I want to see the way the accused has committed the offense. I want to see if he is a first-time offender or not. I want to see if he's committed a crime against humanity. I want to see, for me to decide whether it is summary or indictable, you are looking at the way the offense had been committed. So you can have a less serious offense, and you can have an accused who is an habitual offender. If I have an accused that is an habitual offender, I'm most likely going to file an indictment because he's going to cool off in prison for a longer time for being an habitual offender, for being a problem to society. But if I have somebody that just committed offense for the first time and the way he did it is more or less like, oh, well, not much thought were put into it, I was okay, I'm just going to file a summary case so that you get less than 2 years. Does this make sense to us? So it goes to the penalty and then it goes to procedure. That is the way you look at it. And for the purposes of exam, well, this is also a typical thing for exam review. What I didn't mention before is after our intensive classes, we would have an exam review workshop as well. An exam review workshop is where we begin to zoom in on what you should put down in your paper and what you shouldn't put down in your answer booklet. So we'll be looking at things critically for the exam review. For those who attend our intensive classes, that exam review workshop will be free. But for those who didn't, they would have to pay. Okay, so just to, because there are some issues that are best for exam review. You know, at that point where you've digested your syllabus, your course content material, you know that you're ready for exam. That is when you need to look at what you need to put down in your exam question, answer booklet or not. So I leave that bit I was about to talk about for exam review, right? Then your next chapter will be interpreting criminal provisions. This one is important as well. Do you know why? Because when you look at your provision and you want to see how you interpret it, the focus had always been on what they call a strict construction. A strict construction in the sense that you look at the provision and you see if there is any ambiguity. If there's any ambiguity in the law, the strict construction principle says that you resolve the ambiguity in the favor of the accused person, right? And then the legislature begins to see that, oh, well, in as much as we don't want to jail someone that had not committed an offense, but the moment we begin to interpret our provisions strictly that way, and the accused begin to get the benefit of all the ambiguities in our law, we may not have been able to portray the intention of the legislature. And that is where your purposive interpretation comes in. What is that one? That one is telling you that when you are interpreting your provision, you should consider the intent of the legislature. Consider the intent of the legislature. That way, you are able to interpret the provision in a just and efficient manner that favors every member of the society, right? And they gave that your case of Aram Pare under that. Right? Your Aram Pare is also under strict construction. That's where they were trying to explain how your purposive interpretation is important. So your Aram Pare, I think, was a case of a guy that committed assaults. Oh no, killed somebody while assaulting. So the legislature had to interpret the meaning of while assaulting. It's another case with Zimin. But in that interpretation of while assaulting, they applied the purposive interpretation because this guy actually killed the guy 2 minutes, I think thereabout, after committing the assault. So the issue was, did the crime arise during the commission of the offense? Are you with me? Am I making sense? So that was the issue. So if you had to interpret it using strict construction, your conclusion would be that no, the person died after the assault now. So there is no anything to talk about. But if you have to use a strict construction, if somebody commits an offense and it happened 2 minutes after the offense, it is logical and reasonable to say that it was while committing that offense. We'll look at that case, right? But I'm just bringing it out to highlight to you the importance of applying your purposive interpretation. Are we good so far? So I've touched on the introductory parts of the syllabus. I would like to hear us. I would like to hear observation, question before I go on into the elements of criminal offense and regulatory offense, which I consider the most important for this section. So please unmute your mic. Have I helped you so far? Do you understand what I've said so far? Do you have observations, comments, questions? I'll take them from here. Right? Please, let's shoot. Anybody? Anything you want to say something? Do you understand what I've said so far? Do you want me to shed light on some things, or you want me to, clarify issues? So just come in. I want to hear you. I don't want to be the only one hearing my voice, so to speak.
Okay, just I have a short comment.
Okay.
When we're talking about interpreting the criminal provisions, right?
Yeah.
We know that for criminal trials, and it's always beyond reasonable doubt, right? And if there's any doubt, we give it in favor of the accused. Is that why you mentioned the issue of there was something you mentioned about that is different from the normal interpretation, and that if anything, you should give it. You should interpret it strictly in favor of the accused. Is it just because of that whole whatever beyond reasonable doubt and all that? Is that why they are giving it the strict? Yeah.
Yeah. Okay. So yeah, Musa Bello is Yeah, you are on track, but we are not there yet. But yes, because of the principle or the rule that says that the prosecution must prove its case beyond reasonable doubt, it is important that you apply this, you understand this principle of interpretation, so to speak. But when you're talking about interpreting the provision of the criminal code and the burden of the crown, they are two different things. Even though if you have a deep understanding of the cause, you can relate it just like Musa Bello had done, but they are two different things, right? So you are looking into the provision to see how to interpret it, because you have to give it the proper interpretation first before you go into the burden of proof on the crown. They are different, but they are also connected one way or the other, because essentially you cannot convict an accused person unless the crown prove beyond reasonable doubt that that offense had been committed by that accused person, right? But here focus is on the test of the criminal law. How do you interpret it? Do you interpret it strictly and resolve ambiguity in favor of the accused, or you adopt the purposive interpretation where you look at the ambiguity and then you look at the intention of the legislature? If at the end of the day you look at the intention of the legislature and there is still ambiguity, that ambiguity will still be resolved in the favor of the accused. Do you understand that? What this is just telling us is that we have to consider the rationale behind the enactment of that law first.
Okay.
Is this clear?
Yeah.
If after doing all of this, you still find ambiguity, then of course the accused will take benefit of that ambiguity. Right? Can we proceed? Is there any other? Okay, please go ahead. Ifeoluwa, shoot.
You made mention of something that I just want to clarify. You
Yeah.
said the difference between a regulatory offense and a true crime is that for regulatory offense, both the federal and the provincial government can, make laws on it or something? I didn't get that.
Yes, okay. Both the federal government and the provincial government have the power to make regulatory offenses.
Okay.
But for true crimes, let me just finish. But for true crimes, that's your criminal law provisions itself, where you have those 3 Ps I told you about. It is only the federal government that can enact laws on it.
Okay.
Yeah.
Then you said about defense. When the defendant is making his defense, that it is based on balance of probability. Is that it? That's the standard of proof.
That's the standard. But we'll dig more on that, right? So when we come to defenses, we'll probably shed more light. The first thing the accused will be doing for defenses is to show some sort of air of reality to the case, to the defense is introduced. And your air of reality test is a test. We'll look at it very well as well. It's just simply saying, does this defense make sense? Air of reality. Is there any sense to it at all? Before the court begins to bother whether you've proven it on the balance of probability or not. So that's the first thing. I just want to put that down for you so that you're not only writing down balance of probability. There are 2 steps to it. Okay? So if that is clear, can I proceed? Is there any other question? I'm getting feedback. Somebody's mic is unmuted and they are having a great conversation in their house. We don't want to be part of that conversation. Who could that be? Let me see. Okay, it's muted now. Fantastic. Okay. So if there is no other comment on what we've done so far, I would now go into the next segment, and that would be the elements of criminal offense or regulatory offense. Like I said, we all have done criminal law. We have a great idea of what this is about. Before a crime can be said to be committed, there must be actus reus and there must be mens rea. Your mens rea is the intention. Did you intend to commit the offense? Your actus reus is the act. Did you actually commit that offense? Those are the 2 things you'll be looking at. Now, what is peculiar to Canada is that for your mens rea offenses, they still now break it down into 2. Sorry, for your mens rea element, did I say offense? Element. For the mens rea element part, you still have two. It was further divided into two. And that would be your subjective mens rea and your objective mens rea. Your subjective mens rea and your objective mens rea, right? Before an accused person can be convicted, the prosecutor or the Crown must prove beyond reasonable doubt these two things, the mens rea and the actus reus, right? Now let's zoom in on mens rea. Let's pick mens rea. For mens rea, like I said, there are two types. Subjective mens rea and then objective mens rea. For your objective mens rea, it says to you that you are looking into the mind of the accused person himself to see if he intended to commit that offense. His mind only. The accused person, he or she, what was he thinking at the time of committing the offense? What is his intention? What was his intention? You are looking into the mind of the accused person himself, right? Now, I will leave the objective mens rea for now and zoom in into the subjective mens rea, because the subjective mens rea was now further broken down into like 5 different types. They are all listed in your syllabus. Are we together? I can't see Raghav. He was with me. I can't see him on my screen. I can't see Musa Bello. I can only see Semira and Ifelu. I want to see all your faces. Please come, put on your camera, okay? So that it's not just me and Ifelu and Semira having some sort of Beijing conference, okay? So, yeah, I was talking about subjective mens rea. Thank you for putting on your camera, Raghav. So for your subjective mens rea, the syllabus is telling you that you would also look at different types of subjective mens rea, right? So you have your subjective mens. Do you have a question? Okay, go ahead, Raghav.
A very small question. Are we saying for subjective mens rea that we look into the mind of the accused? Is that correct?
Correct.
And for objective, we look to others like a reasonable person. Is that correct?
That's very correct, but I haven't said that on this call. I haven't gone there yet, but you are correct.
Okay. Perfect. Thank you. Thank you.
I want us to take it step by step, right? So we don't confuse issues, right? So yeah, I was talking about subjective mens rea. The first one you have on your syllabus or in your syllabus is intention and ulterior mens rea. Intention, and this they've said is the utmost, level of mens rea that an accused person can have, because the Crown must prove the actual intention of the accused person. And they've said quite a number of times that intention is a very complex issue, because actually and factually nobody can tell the intention of anybody, right? But how do you begin to understand intention? By reviewing the circumstances of the offense, right? So you hear things like intention is discerned from the circumstances surrounding the commission of the offense, right? So this particular type of intention is looking at the very intention required by the section of that offense. One of the things we'll be achieving in class is to know how to identify this intention when we review sections. So what this one is telling us now is that you have to look at the section itself and see the kind of intention that the legislature intend for that offense, right? I'm tempted to say that we go through some of the offense sections, but that would take a lot of time, and that is actually ideal for the class, not for introductory class. Right? I'm tempted to do that, but I'm not going to do that. But what I'm trying to tell us is that for this intention and ulterior mens rea, you are looking into the actual intention of the accused person, and then you are trying to see if that is the intention that the offense section requires. Anything short of that would not lead to a conviction. That is the first part. Raghav, you see why I asked you to put on your camera? You look to me now like you're confused. Do you need clarification?
And just for the last part that you just said. The last part, I missed that actually. If you could please say it again.
Okay, what I'm saying is that for every offense section, the legislature has put in the provision the required intention for that offense. And the prosecutor would have the duty to prove that particular thing that the legislature intend. So now in establishing that, you would now have to look at the intention of the accused and place it side by side with what the law provides. Anything short of that cannot lead to conviction. Is that clear? That is your intention and ulterior mens rea. It is the highest level you can have actually. If you go deep into your course, they will tell you, you read it there. Because for some offenses like murder, where you can be sentenced to life imprisonment, where you will not have, for example, first-degree murder, you will not even have a right to probation until after 25 years in prison. Those are serious offenses. Those are very grievous offenses, and the law would not intend to sentence you to such a punishment if the Crown is not able to prove the required mens rea for that offense. Does that make sense to us? Yeah, so that is why for some offenses, the mens rea is high. The prosecution must go all in to prove, otherwise it cannot result to conviction, right? Then the second one you would have is subjective mens rea with objective feature. I had a one-on-one with some of my candidates for the August exams, and I know that we dealt a lot on this type of mens rea, and I'm glad we did, because the last exam actually got a question on fraud. This type of mens rea is required for two types of offenses. Again, if you have your syllabus, it is subjective mens rea with objective features. First, I will explain what it means, and then I tell us the kind of offenses it is applicable to. So what your subjective mens rea with objective feature means is that we all know what the word subjective means, right? I realize I didn't even say that. Subjective means that you are partial, you're looking into something, one person, right? You are zooming in on one person, subjective. And we've said that there are different types. We've mentioned the intention and the ulterior motive one. And now we are talking about subjective mens rea with objective features. So what this one is saying to you is that for whatever offense this one is related to, first, you prove the intention of the accused. You look into the mind of the accused to see if he intended to commit that offense first. So there are two legs to this one. The first one, you look into the mind of the accused to see if he intends to commit the offense first. Then the second part will be that you now place that accused. The objective part of it is that you now place that offense or his act of committing that offense in a reasonable man's situation. And the way it will make sense for you guys now is for me to now mention those two offenses that it is applicable to. The first one is sexual offense, and the second one is fraud. Subjective mens rea with objective features, the moment you go into your exam and you begin to see question on sexual offenses, you begin to see question on fraud, you know you are running to this place because that's the intention that is required. Two offenses, sexual offenses, fraud. So for this one, the subjective part is that you are looking into the mind of the accused to see if he intends to commit the sexual offense or the sexual assault. What is assault? I won't dig deep into this one. But when you commit assault, you are touching somebody intentionally without their consent and you are applying force. That is assault essentially. So your sexual assault simply means that add sexual to that assault. When you touch me intentionally by force without my consent in a sexual way, it becomes sexual assault. As simple as that, you know. So now I said this type of mens rea is used for two types of offenses: fraud and sexual offense. So I'm picking sexual offense as an example so you can understand what this type of mens rea is. So for the sexual offense part, the first question you are asking is, did the accused intend to even touch me sexually? There are certain parts of your body that when somebody touches you inappropriately, you begin to think of sexual assault. Your private areas, you know, somebody has come to touch me in my private area and is saying he didn't intend to sexually assault me, the first thing the Crown is doing, look into his mind. Did you even intend to touch that person on that part of their body? The moment you answer that question in the affirmative, that you intended to touch me in my private area, the objective leg of this mens rea, that objective feature now says that the moment I answer that question in the affirmative, whatever explanation the accused have or is going to have becomes irrelevant, because I'm now applying objective feature to it. I'm now saying that, would a reasonable person consider this touching sexual assault? Say, for example, I touch you inappropriately. Then I go to court to say, oh, well, I touched her there, but I didn't mean it to be sexual assault. The Crown will tell me to shut up, because the law has applied objective feature to that offense, excuse me, to the extent that the moment I answer the first question, that you intend to touch me in that part of my body, that there is general knowledge that it is sexual. There are parts of your body that everybody understand and agree that it can only be sexual. And you touch me there, and you say, well, you now go to court as an accused person to say, oh, well, I touched her there, but my understanding of that touching is not sexual because that's not my own understanding. The Crown will say, no, you have to keep quiet at that point, because now we are applying objective feature to it. Does that make sense to us? And you people will agree with me why that should be. Because if there is no objective standard to this thing, people will go to court to say, oh, my own understanding of sexual assault is not that. It's to have a standard. It's to be able to curb the crime efficiently. That is why you have standards. Right? Does that make sense to us? That's fantastic. The second offense of that act is fraud. Somebody is saying something. I'm getting a background. Are you talking to us, or you're having a good conference in your house? Okay, so that is the sexual part of that type of mens rea. The other one, with the explanation I've given, I want one of you to tell me and justify why it is applicable to fraud. With this explanation of sexual assault I gave you, right? I'm telling you that this mens rea is applicable to two types of offenses. One is sexual assault, one is fraud. I've explained the sexual assault. With this understanding of why it is so for sexual assault, are you able to explain to me why it is so for fraud? Can anybody try? Just try, let's hear you, whatever you think. It need not be perfect answer, just say it. I want to see if you understand what I've explained regarding the sexual assault part. Somebody is raising, please talk, unmute yourself and please go ahead.
Okay, can I go?
Yes, please go.
So in my understanding, and this is really my opinion, subjective, that the accused might say, in my mind, whatever I did is not cheating. I did not commit a fraud on this person. But then the question becomes, in the eyes of a general person, like in common knowledge, as you said, is this act of fraud? For example, if I steal money from somebody, like when I fool them or lie to them, like in deception, I'm not defrauding that person in my mind, but reasonably speaking or objectively speaking, is that fraud to a common man? Am I going the right way?
You are spot on. You are spot on. That is it. That is it essentially. Because for fraud, just like Raghav have said, if there's no objective standard to it, everybody will go to say, oh, well, I diverted this money, but my understanding of fraud, that's not it. That's not fraud. In my mind, that's not fraud. Court will tell you to keep quiet. That there is a common understanding of what fraud is and what you have done is fraud. But the first thing they are looking at is that subjective mind. Did you intend to do that thing? Did you intend to divert that money? Once I answer yes to that question, whatever you come to say is irrelevant. I'm applying objective standard to it. I'm using a reasonable man's test. I'm using a common mind. You see? Thank you, Raghav. You've answered that for me. I don't need to talk much on that. So we can move, right? Is there any question on this before we move? I can see, Adiola raising her hand. Adiola, do you want to say something? Adiola, are you with us? Or this hand is just up perpetually because it's been on for a while? Okay. Adiola is not here. Adiola, please, I would like you to indicate if you are here or not, right? Okay, so we understand subjective menstrual with objective feature, right? Let's move on. The next one is knowledge. The next one is knowledge. What are we looking at for knowledge? For knowledge, you know, you begin to look at the mind of the accused as well. And you're basically wanting to see if he knew, just from the word know, if he knew of the existence of a particular act, for me to be able to say that you intend to commit a crime. Knowledge. Basically, that is it. So you look at the, the mind of the accused to see if he is aware, if the accused generally know the conditions that the law has stipulated as offensive. I don't know if that makes sense. If the accused is aware of the conditions of the Actus reus, if he's aware of the condition of the Actus reus, then you would be able to impute knowledge on him. And I'll give you an example. The example that was given in your syllabus. It says to you that if ID is the accused person here, and I see a police officer, and I go assault that police officer, and they've now charged me with assaulting a police officer, the fact that I know that that person standing is a police officer is enough for the Crown to impute knowledge to me that I intend to assault a police officer. Does that make sense? So the moment the accused know of the existence of the Actus reus, because in your section, actually, one of the offense sections, assaulting a police officer is a crime, right? So the moment the accused person is aware that the person standing is a police officer, and then he goes to assault him, right? All the Crown would have to do is to show that I had that knowledge that is the police officer. That would be my focus. Excuse me. That is the focus, right? Just oppose it with a situation where the person standing is a police officer, but he wasn't wearing a uniform, or he wasn't, doing anything in the course of his duty. I had nothing to tell me that he's a police officer, and then I assault that person. The Crown cannot use knowledge against me because there is nothing for me to see that he's a police officer. Does that make sense? So knowledge is a type of mens rea. It's a subjective type of mens rea. Canadian law is beautiful because what they did is just to, zoom in on these things, because I worked as a Crown before I left Nigeria, right? Sorry, as a prosecutor, I'm used to Crown. I worked as a Crown. So these are the things you would actually be doing, right? When you want to impute knowledge, or when you want to impute mens rea to an accused person, I will be looking at circumstances. Oh, did he know? Even though my law did not put it down for me this way. But realistically and practically as a lawyer, these are the things you'll be thinking about for you to impute mens rea, for you to impute that intention to the accused person. These are the things you have to look at. But here, what they just did is to put it down, for you to see clearly and straight up, right? So that is knowledge. Do we have any question on knowledge? Excuse me. Is there any question on knowledge? Are we clear on knowledge? Excuse me. Ifeoluwa, are you okay?
I just want to clarify if all these points that you've listed out have to coexist before you can say there is a subjective mens rea, or is it either of them?
That's a great question. So straight up is either of them.
Okay.
It's either of them. There are different ways that the law expects that you prove mens rea. And these are just the different ways. Right? Okay. I'm sorry, I'm picking on my lips. Yes, I'm sorry. Okay, so the next one will be willful blindness. Willful blindness. So this one is pretty straight up as well, because the moment you impute knowledge or you have reasons to believe that the accused is aware of the existence of actus reus, but instead of him to act accordingly. So let's continue with the example we used. I know that this person is a police officer, then I go assault him. Or for example, let's know, so if your police officer has, would probably have a uniform or have his handcuffs. Sometimes you see them without uniform, but then they have the handcuffs on their person. Let's use that example to explain willful blindness. So willful blindness is a situation where you could have known of the existence of that act. You could have known of the existence of that actus reus, but you chose not to know. You chose not to know just to be able to say to Crown that you didn't know. You could have known if you inquire further. Let's use that police officer without a uniform, but with handcuff. I've seen a man standing so in a straight up way, just like you see military men standing, and he has that handcuff on his waist. This may not be a sharp example, but just so that you understand willful blindness. I knew if I asked him, for example, just for example, are you a police officer? You probably tell me yes, because I already had indication that he could be a police officer by seeing that handcuff. Even though I don't know for sure or for certain, because I'm not seeing him with his uniform, but I could see that he may be a police officer, right? But I chose not to inquire further. Then I assault him. Then I go to court to say I didn't know that he was a police officer. The Crown will tell you to shut up. That you could have known he was a police officer if you had inquired further. That is willful blindness. You chose to be blind to the existence of a particular fact. It is another type of mens rea. Does this make sense to us? Is that clear? We can move on, right? So the next one is recklessness. Recklessness is another type of subjective mens rea. Most often than not, people confuse recklessness with negligence. Recklessness and negligence are two different things. Have that in mind. Stock it somewhere. Because right now, right here, we are talking about recklessness, not negligence. We'll talk on negligence, right? Negligence is a subjective type of, recklessness, not negligence. Recklessness is a subjective type of mens rea. When would you begin to think about recklessness when you are trying to review your provision? When do you begin to think about it? For all these other types of mens rea I've mentioned above, your ulterior intention, subjective mens rea with objective feature, knowledge, willful blindness, they are words that help you to identify them in the criminal code. Words like intention. Anybody who intentionally touches anybody for the purpose of intention, one word. Another one, willfully. Anybody who willfully, whatever way is couched, you see. Another word, know. Anybody who knows, anybody who knows. These are words telling you that what is required is a subjective mens rea. But for recklessness, when would you begin to think about recklessness? You look into the provision that you've been asked to review. You do not see intention as a word there. You do not see know as a word there. You do not see willfully as a word there. You begin to scratch your head. What kind of mens rea am I looking for? What you will do quickly is to look to the facts of your case. Look to the fact of the case they've asked you to review, the question that they've given you in your exam. See if you can see facts of recklessness in that question. What is recklessness? Let's start from there. Recklessness is when an accused person sees that an act can result to injury, but chose to do that thing anyways. He saw it, that this conduct, this act can lead to injury, can harm somebody. He saw the risk with his eyes, but he chose to commit the act anyways. You would know when you see the fact of your case. You will see it, you will read it there. It will tell you things like, one popular example is a teacher on excursion with children, and they were going to go on a lifeboat, on a life cruise, and he knew that he ought to give these students life jackets. He knew that if they don't use life jacket, because there is danger anywhere, right? In the sea, the boat could capsize, anything could happen. It is common knowledge, general knowledge, that you would need lifeboat. You know, he saw that risk, right? But he took that risk anyways. It was reckless. So why recklessness is subjective is that we must tell the Crown, we must tell the examiner that the accused saw the risk himself. He is aware of the risk and he took it. I want you to understand that, because this is the sharp difference between recklessness and negligence, right? The accused must see that risk himself, his mind. We are looking into his mind to see if he saw the risk. The moment he takes that risk, then you can begin to say that he's reckless. So if you look into the provision you've been asked to review, you don't see no, you don't see willful, you don't see all these words that point you to mens rea, but you've noted in your fact of your case that your accused was reckless. You will be applying recklessness as a mens rea to that offense. Your recklessness becomes your mens rea. It is the subjective mens rea that will be required in that instance. Does that make sense to us? That is recklessness. Is there any question?
Yes, I just wanted to avoid my confusion here, just to clarify and just to understand whether I got it right or not. So I think I'm a bit mixed up between willful blindness and recklessness here, because in both the accused sees something but like ignores it, right? In both of them, I'm seeing that. So are you saying that the fact pattern will tell me whether I'm supposed to apply recklessness or willful blindness? Is that what you're saying?
No. What I'm saying is that, which is one of the skills we'll build in the intensive class, right? For willful blindness is looking, first you must say that the accused person knows. For recklessness, you are looking at risk. You are taking a risk. For willful blindness, your focus is on knowledge. Did he know the existence of an actus reus? Like the example I gave of the police officer. Does he know that this is a police officer? But when you come to recklessness, the focal point, the key word is the risk. If he's taking a risk and he knew that this risk he's about to take will result in harm, and he took that risk anyways, not minding the consequences, the law is telling you that you impute recklessness to him as mens rea that is required. Does that make sense?
Yes, guys,
so,
thank you.
Yeah, they are similar. You're right, Raghav, but that's one of the things we'll be doing in the intensive class. And that is why I say to people, yeah, criminal law is interesting. I love it, right? But I know it is tricky. It is quite tricky because there are sharp differences. And if you don't know them, you confuse things, right? That was a good question, Raghav. So that is what? Recklessness. All along, what we've been talking about is mens rea. We've not touched on actus reus. I hope you know that. right? Are you with me? And all along, what we've been talking about as well is subjective mens rea. We've not touched on objective mens rea, right? So I want us to place these things properly, right? So that we have a good structure of them in our head. When you place them, you know, just like your shelf, when you place things where they should be and you arrange it properly, when you need to pick them out, you are not confused, right? That's what I'm trying to achieve here. I don't know if I'm doing a good job at it, but that's what I'm trying to achieve. So we've touched on subjective mens rea. We now need to talk on objective mens rea. Objective mens rea, there's not much to it. And, but I'll give you a background why objective mens rea has become very important. Before now, the law had been focused on subjective mens rea. Do you know why? Because the law is careful of convicting the wrong person. For objective mens rea, you will be looking into the mind of the accused person. You would want to see if the person actually committed the offense before you sentence them. But for objective mens rea, you will not be looking at the mind of the accused person. You will be applying the reasonable man standard to impute intention. You see, that's tricky. Because if you are not looking into the mind of the accused person, there is a tendency that you may wrongfully convict somebody. And the law is careful. The law does not want to do that. But again, there are some offenses that if you decide to use subjective mens rea for, it becomes difficult to prosecute. It becomes hard because the Crown would not be able to prove the subjective mens rea. And then what happens? This crime continues and it will place the society into jeopardy. So the law has to accept objective mens rea. But there are ways to it as well. So even though the law is adopting objective mens rea, the law is also very careful in doing so, right? So for your subjective mens rea, you're looking into the mind of the accused person. I'm sure we all understand that now, at least have an idea of it. In class, we'll dig deeper. But now we want to talk about the objective mens rea. You know, for your subjective mens rea, I say you're looking into the mind of the accused. For your objective mens rea, you're looking into the reasonable man's test, reasonable man's standard. Would a reasonable man do what the accused had done? That's simply the question you're asking, right? Would a reasonable man do what the accused had done in the circumstance? So you are placing the accused into the shoe of a reasonable person, and you're asking that question, right? So that is a good way to, you know, shelf it. Now, for your objective mens rea, you know, rather for your subjective mens rea, you know to look out for some words, right? That points you to subjective mens rea. And when you don't see those words, you know as well to apply recklessness. At least that is clear now, right? I'm not getting feedback. Is that clear so far? But for objective mens rea, great. For objective mens rea, right? What word will you be looking at for you to know that the law intends for you to apply objective mens rea? Don't forget your objective mens rea is a reasonable man's mens rea, is a reasonable man's standard. What are the words that you'll be looking at to identify that the law is asking you to impute an objective standard to it, an objective mens rea to it? It's not a word, it's a phrase. I call it a phrase. You begin to see ought to know. Ought to know. You know, for your subjective mens rea, you are saying anybody who knows. But for your objective mens rea, you are saying anybody who ought to know. Anybody who ought to know. Ought to know is objective because we are looking at you and we are putting you in a reasonable man's state to say you ought to know this. It is common sense that you know this. Anybody who ought to know, right? Just like I did for subjective mens rea. When you don't see this phrase ought to know, what do? You want to scratch your head a bit like, oh, the phrase is not there. How do I know the law, what menstrual is required? What do? You look as well into the facts of your case. Are you with me? You look into the question that has been given to you in class, rather in your exam. What are you looking for? For subjective menstrual, you are looking into whether your accused is reckless. What is your recklessness? You are looking to see if he saw a risk and he took the risk for subjective menstrual. But for objective menstrual, the moment you don't see ought to know, what you are looking for, you quickly go to your question and see if there is anything like negligence in it. Are you with me? You know, I told us that recklessness and negligence, they are two different things, right? And I touched on recklessness. Now I'm talking about negligence. Negligence is an objective standard. Recklessness is a subjective standard. For negligence, you are looking into the fact of your question. What are you looking for? Did the accused, even though he did not see a risk, would a reasonable man in the position of the accused would have seen that risk? Would a reasonable man have seen the risk? Right? So you look into that your question that they've given you, that the NCA had given you in your exam, to see that even though the accused did not see this risk, would a reasonable person in his circumstance, would he or she have seen that risk? The moment you answer that question in the affirmative, you know you'll be applying objective menstrual, and you'll be telling your examiner that the accused was negligent. The fact that he was negligent is an objective standard that imputes intention to him. Does that make sense? Now, there are tests to this thing. The law requires that this negligence of the accused, you must have deviated markedly from the reasonable man standard. We'll look at these things in the class, but there are tests to it as well. So the moment you say he's negligent, then you now want to unpack negligence, because there are different types of negligence as well. Does this make sense? It is impossible to cover everything in this introductory class. The purpose of this introductory class is to jolt you, to provoke your mind, so that when you're reading and you're seeing these things, you will hear my voice in your head and you begin to say, oh, I did say this, I did said that. Then you begin to, that is the purpose of this introductory class, right? Does that make sense to us? Do you have any question? No question. Samira, unmute your mic. I want to hear your voice a bit. Are you clear?
Yes, I am.
Yeah,
that's why I don't want to, say so much.
Sorry, I didn't get you. What did you say?
I said my baby's singing here, so I don't want to disturb and distract us.
Tell him we love him. Him or her, we love him. You can mute yourself now.
Okay.
I just want to know that you are with me. Okay, so that is that for your menstrual. I hope you also do realize that everything we'll be talking about so far had been on menstrual. We've not talked about Actus reus, right? So I think it's safe to talk about Actus reus now. Are we clear? Ragav, Ifeoluwa, who else? I can't see everyone on my screen. I wish I could. That way I'm able to tell if you're with me or not. If you could put on your camera, please. My admin may probably remove any of you, and I don't want that to happen, because that's the instruction they have. They'll probably give you some grace of some time, and if you're not putting it on, they'll just remove you from the call. I don't want that to happen. So, yeah, for those I can see right now, before my admin decides to remove anybody, is this clear? Can we move?
Now I'm with you, so let's move on. Yeah.
Yes, clear.
Okay.
Yes,
that's great. Okay, great. So let's go to Actus reus. Actus reus is not as complex as menstrual, so we won't waste time on that. So your Actus reus is just that act that the law had prohibited. Whatever the law says you shouldn't do, and you do it, and the prosecutor can prove that you've done it, then the Actus reus has been proven. But for actus reus to be proven, you need to prove as well that that act that I've committed, I've done it voluntarily. It has to be voluntary. It has to be willful. This is the basis of your defense of automatism. I hope we have time to talk about that. It's connected because the moment I do something, even though it is my act, but I do not have the control of that act. I have done it involuntarily. I didn't mean to do it. Even though I've done it as per the tests of the criminal law, I will not be convicted for it because one of the essential elements that goes to the principle of fundamental justice is that that act of mine must have been done voluntarily. So that's first. And I said it's connected to your defense of automatism. Hopefully we'll have time to talk about that. But that's the basis of your defense of automatism. You have to show that the act that I've done is voluntary. And I'll give you an example. And I think that example is in your syllabus as well, in one test. I've read it somewhere. If an accused person standing trial had done something and is suffering from a disease like seizure, so my hand is like this, and I can't control it. It moves, and it moves in such a way that I now slap Ifeoluwa, and they've now accused me of assault. I would say, well, I slapped her, but I couldn't control my hand. I couldn't control my hand. How can you charge me? That's not an assault because the law says that you must show that I intend to do that I did it willfully. I didn't do it willfully. I'm just suffering from a disease. My hand cannot stop itself. So please, excuse me. So that is it. Does that make sense? So that is the first thing you are proving for actus reus. You must show that that act was voluntary, right? The other thing you will be showing for actus reus, which this one, they linked it a bit to the offense of possession. I don't want to confuse us with that, and I don't want to go into that right now. But for it suffices to say that for actus reus, there is that argument that you come to see when you read that sometimes it is hard to divide or find the thin line between mens rea and actus reus. The divide sometimes is not sharp. And that is where your offense of possession comes in. And you will see your syllabus, they mention possession because they want to draw your attention to it specifically. Because for possession, if you have to charge me for possession of something, you are charging me for being in possession, and you must also prove that I intend to be in that possession of that and to deprive somebody else of it. So it's together, right? So I can be in possession of something, which is an offense, and I may not intend to deprive of somebody of that thing. You can see it's not so sharp, but it's just an example so that sometimes you find yourself with a provision in the criminal code that you are not able to divide mens rea from actus reus. It could be mixed up like that, and your possession is a good example of that. Another very important element of actus reus is consent. Consent. For an offense of actus reus, or for an act to be complete, the prosecution must prove that the victim did not consent to it. If I slapped Ifeolu, I'm sorry, I don't mean to slap you, I'm not a violent person. If I slap Ifeolu, for example, and she told me to slap her, slap me. I'll give you an example, a good example from your case laws, but let's finish with this example. She says, go ahead and slap me, and I slapped her, and then she cried foul and said, oh, she slapped me, she should be charged. I'll simply go to court and say, oh, well, I slapped her, but she asked me to slap her. The actus reus will not be complete in that instance because you consented to it. Does that make sense? But this consent we are talking about is also a very important conversation to have. We have to unpack consent because there are many things attached to consent. For example, your consent must be clear. You must You cannot say I've given consent, for example, when you threaten me to give you that consent. You cannot say I've given you consent, for example, when I'm abusing my authority as a person. You cannot say I've given consent when you got that consent by fraud. Those are the three things that vitiate consent. Right? So consent is another thing to talk about, but we can't talk about it all in this class, right? And then it's suffice to say that the consent, for the Crown to look into consent, you are looking into the subjective mind of the victim. So just like you did for your objective mens rea, when you're talking about consent, you are also looking at the mind of the victim herself or himself to see if he gave consent or not. A very important case we'll be talking about here, excuse me, is the case of Aranjobidon. And this is where your common law is playing a role in this case, Aranjobidon. Aranjobidon is telling you basically that nobody can consent to the infliction of bodily harm. Say, for example, myself and Ifeoluwa decide to go into a combat. We are combatants. We want to show our prowess that we can fight. We agree to go into a duel. We agree to have a fight. And then in the course of the fight, I begin to inflict harm on her to the extent that it leads to bodily injury. And I'm charged, and then I go to court to say she consented. The court will tell me to keep quiet. Because common law, in the case of Aranjobidon, is saying that nobody can consent to the infliction of bodily harm. It has to stop. Even though you consent to fight me, I would not consent for you to inflict bodily harm on me. Injury. So here they are looking at gravity. So those are things to talk about in class. I can see you guys' faces. Ifeoluwa is looking like, oh no, what's she talking about now? But basically what I'm saying, I hope it's clear. Do you need me to clarify that?
Yeah, I'm just thinking that the situation the example you gave right now, it's anyone going into a combat knows that there's the likelihood of getting injured.
That is it.
So
that is a good point. But that is where your law also comes in. That if I agree to go into combat with you, and this is law, you can't argue it. If I agree to go into combat with you, I do not agree that you should hurt me, harm me to the extent that I bleed, or I cannot. It is unreasonable for me to say that I agree to that. And this case I actually talked to you about was a case where they actually agreed to have a fight. And the law is saying no. Because you see, the thing with criminal law is you need to begin to contextualize it as a member of society. Imagine if the law allows everybody to go into a fight and kill themselves and say, oh, well, you agree to the fight. Can you imagine how chaotic that would be? There has to be a standard. There has to be some way of regulating people's behavior. And that's essentially what criminal law is about. They are regulating people's conduct.
Okay, but in this kind of situation, what if the parties had already discussed the possibility of an injury occurring? Can I talk about consent?
We are not. This is not contract law. If you look at this is not. This is criminal law. I see your point, and you're actually talking as a lawyer, because you could say, okay, I know there is possibility of harm, but I agree anyway. Let's do this. Let's fight to finish. But the law is telling you that there is a limit. There's a limit.
There's a limit.
Common law will come and say to you that even though this person agreed to fight, but once you see that he begins to converse or you stop there.
Okay.
You stop there.
I think I now get your idea of gravity. I think that's where the idea of the gravity now comes in.
Yeah, don't kill me and then you go to court to say I consented to death. Who are you going to tell that one? Ragav, are you with us? Samira?
Yes, definitely I am. I just have a small confusion going on in my own head as well. So about consent, that no one can consent to a bodily harm. What about the harms associated with sports, for example? If I go to play a game and I get hurt in the middle of the game, by accident someone punches me in my face in that game. So for example, in a boxing match, for example, am I consenting to bodily harm there or not?
I like the way you guys' minds are working. Honestly, you see, this example you gave was actually the fact of a case, Aaron Smithers. It happens, the law envisages that these things will happen, and that is why it is in your book to start with. So now you go into a sport, and the kind of sport you go into that would involve you hurting yourself is reasonably expected, right? But the moment you are in a sport and you hit someone and the person is down, and you continue to hit the person, all in the name of sports, that will not be allowed. We'll look at these cases when we come to class, assuming you guys join my class anyways. But there are discussions to have, like, you need to, but the way your mind is working is fantastic. It means you are with me in this class. It means your mind is working. That's okay. But we can't go deeper than this right now for this introductory class, right? But I'm glad you are smiling now. You see why you should turn on your camera. You see, the people taking the benefit of this class are the people who actually turned on their camera. Okay, so what will be the next we'll talk about? How long do I have? I think my time is up, actually. My time is up. I was just going to touch on regulatory offense, and this topic is important because the last exam touched on corporate liability. Samira touched on corporate liability, right? And you guys had to talk about fraud. And the question was asking you specifically whether section 22.2 would be a strict liability offense or absolute liability offense. That's a very tricky question. I wish I had the time to look through it. But these are the things we'll be looking at during the class. So how can you join our class? You can register on our website. You can send us email inquiries at ncaaguides.com. You can email me personally. I would like to hear feedback of this class from all of you. You could email me idayat, idayat at ncaaguides.com. Yeah, this call was recorded and you may have access to it on YouTube. What else do I need to tell you? Yeah, our classes will begin in 2 weeks. It will be 4 session intensive classes of 4 hours each. We'll be giving you materials like I've explained earlier to you. What else have I been instructed to tell you guys? Okay, pretty much I think that is it. I look forward to seeing you in my class. I hope that this class has been beneficial to you and you've learned as much as possible to dig into your course materials. When you do read your course materials, please read it with interest because you'll find it very interesting. And we're going to have lots of interesting conversations in class because at the end of the day, you will be able to tackle your NCA exams. What we intend to do at NCA Guides, it's not just to give you the key notes that you need for the exam, it's to give you understanding. I'm sure you all know from the nature of the question NCA had been setting, NCA had been more specific than general now. So if you do have a general knowledge, but you don't have specific knowledge for the exams, I don't want you to fall the victim of people who got into the class and into the exam and they left with utmost confusion, right? We can avert this, we can stop it by joining the class and having a good understanding of criminal law. I hope to see you all faces. Please drop me email. Would like to read from you. Would like to know that you'll be joining the class. At this point, I'll be saying goodbye. Thank you all for joining the class. You can unmute your mic and say a goodbye if you wish. So thank you.
Thank you.
Thank you so much.
All right, thank you. Thank you.
Thank you.
You're welcome. You're welcome. Have a good day, everybody.
Bye.